All right, let's get this started. Hi all, my name's Calvin. I'm from Hudson Gavin Martin. We're a law firm that focuses on tech, media, and IP. And I'm giving a presentation today on IP and how to protect it mainly. So, oh, I think my laptop turned off. But today, my boss was supposed to come with me today to give the other half of the presentation, but since he unfortunately he couldn't make it, so now you're stuck with me covering his half, but we'll see how it goes. So a bit about me. This is kind of my gaming chronology. My first Final Fantasy was Final Fantasy VIII. Final Fantasy VII was released before I got my PlayStation, so I grew up with 8 instead. 8 introduced triple triad though, so that might explain my addiction to card games, as you can see there. And MapleStory was the game I played during the golden age of MMOs. You were either playing MapleStory or World of Warcraft, and had very little time for non-essentials like homework and exams. Did anyone else here partake in no-lifing either of those two games? Just me. All right, excellent. I'm the only degenerate here. That's good to know. I'm in stand-up company. Currently, I'm playing a tactics RPG called Sword of Convallaria. If any of you have played Tactics Ogre or the Final Fantasy Tactics series, that draws a lot of inspiration from that. But what does all of this have to do with IP and legal issues? Well, nothing. I just wanted to let you know what kind of person you're getting advice from. And as a note, don't expect any fancy graphics or videos in this presentation. I've designed it to be as unstimulating as possible. Just black text on white background, so that only the truly deserving can learn anything from this. All right, so legal issues, so split into 2 parts. Legal issues relating to your business, so namely IP and how to protect it. That'll be the main focus of the talk today. And then secondly, we'll go over legal issues relating to your game, such as licenses and laws that you might need to comply with. So in the first part, we'll go over what IP is, what most common forms of IP protection are, and what I want to focus on today, actually, in part B, is one of the most common ways to structure your business to protect that IP. So, and just as a note, while I will talk about IP in the context of game development, most of the concepts here will apply to pretty much any IP-centric business. So let's move to the next part. Why should you care? Well, you should, because basically, if you're an IP-centric business, that's basically your crown jewels. You'll need to find out, you've spent so much time and resources creating it, so you might as well protect it properly. Customers will care about your IP. What if they want to, use some of your IP to promote the game, such as, on a fan website or fan app? What if your game involves user-generated content? Who owns that? And investors will also care about your IP, and so will your fellow founders. They'll want to see that your IP is protected. And lastly, the bunch of authorities will also care, because that's their job. So moving on to understanding intellectual property. First, there are 2 categories. We have intellectual property rights that are registered, and there are rights that are unregistered. So the right that exists by default, and you don't, without any need to register it, is copyright, which we'll go over in a second. But you can also see that there are ways to protect your IP, which require registration. So that includes trademarks and patents. Next, so first off, copyright. So copyright exists from the time that you create your work automatically. It covers it basically covers, protects creative expression. It covers a broad range of pretty much anything that in terms of creative expression can be copyrighted, except, I guess, except kind of things that are too unoriginal to be copyrighted, say like a name or a title. But otherwise, copyright extends to many forms of expression. You know, it can be art, it can be code, it can be a story, it can be photos. But the thing to keep in mind about copyright is that you don't need to register it with any kind of official register in order for you to enjoy the protection of copyright. It exists from the moment that you create your work. The only requirements are, as you can see there, it must be original. There's not, and it has to be an expression of an idea and not an idea itself. So an example of that, of kind of what an idea is versus what an expression of an idea is that a story or plot points would be an idea, but the actual writing, the actual expression of that idea would be the novel that you write to express that story or those plot points. So for example, the idea could be a boy who finds out he's a wizard and goes to wizarding school. But the expression of that idea would be the form of the Harry Potter series, which would be protected by copyright. So, what does copyright do for you? It basically prohibits copying, and you can, if someone does copy, you can sue them for damages, i.e., the harm that they've done to you in copying your copyrighted work. And because the copyright is automatic, there's often a question of who owns it. It usually is the creator, except in circumstances where there's a contract that says otherwise. So an employee in the normal course of employment would not be the automatic owner of that copyright, because in a relationship of employment, it's assumed that the employer will be the owner. In a contractor kind of context, which is different from an employee, you'll need to kind of have a clause in the contractor agreement saying that the assets that they create will belong to you rather than them. So it really depends on kind of the context in which they create a work. Pros and cons of copyright. So pros, obviously, no registration, it's automatic. But because it's automatic and no registration is required, if you ever do need to prove the fact that you own the copyright to something, you need some form of record to show that that's the case, which can often be difficult if you didn't think about it at the time. But often you should be able to kind of like have maybe drawings or prototypes to kind of show that it was your creation. And for trademarks, which is one of the registered IP rights, what trademarks do is that they protect a mark. The mark will basically promote your brand, and that's what trademarks kind of aim to protect. much like copyright, there's a wide range of things that can be trademarked. For example, words, shapes, logos, even colors and sounds and smells can be trademarked, as long as it's subject to a class. So when you trademark something, you trademark it in a class, which would be something like, say, if you were to take the example Fortnite, you wouldn't trademark the word Fortnite in the I guess food category unless you were creating a food product that needed the brand name Fortnite. So, and similarly for all the other trademarks there, you'll need to kind of consider what classes of products that you want to trademark them for, because if someone uses the exact same word or mark but in a different class to yours, then they wouldn't be necessarily prohibited from using that mark. So when you register a trademark, you should consider what kinds of products your trademarks will be used to kind of promote, so that you have all your bases covered and no one can use that mark in that class. Say, if you are in gaming, you use the word Fortnite, then obviously no one else can use the term Fortnite to release a game. Let's see. So while it's a relatively powerful tool to protect your brand, there are some disadvantages that come with having trademarks, and one of them is that in addition to being specific to specific classes of products and services, they are also specific to territories, which means that if you register a trademark here in New Zealand, it doesn't necessarily prevent someone in, say, Colombia from using that same trademark, because it's basically not registered on their register. You would need to, in order to protect your your mark around the world, you would need to register that mark in the various different jurisdictions that you want to offer your product in. So it kind of becomes a cost-benefit to risk analysis to say, okay, I'm offering my game in XYZ countries. I'll register the trademarks in those countries. If someone in Samoa wants to, try it, then I'll take that risk. Not gonna, register my trademark there or something. So, because it can become prohibitively expensive to trademark your marks worldwide. So you kind of just need to kind of consider the cost-benefit analysis there. And because of the territorial nature of trademarks, there are sometimes there are people called trademark pirates or trademark trolls who register trademarks owned by others in jurisdictions that the trademark hasn't been registered in. So I was working on this one deal where we were trying to sell a business, and it was actually quite a large business. So that was the only reason why this wasn't an automatic kind of red flag and stop the deal. But the buyers had to consider that there were some trademark pirates in South America that had basically registered some of the trademarks of that business in South America in the classes that the company was selling products in. And there was very little, actually, that the business could do about it. So the buyer just had to basically say, well, will we ever, operate in that territory? And if we do, what will, how much would it cost to kind of maybe buy the mark off them, or, aggressively push them out of the market or somehow show that they're not using the mark to force deregistration or something. So there are ways to deal with it, but it can be tough to deal with if someone is squatting on your mark in a jurisdiction that you want to operate in. It's also I guess it's also the reason why, part of the reason why at least Burger King is called Hungry Jack's in Australia. If you guys know that story. Cool. So, second part. Now that you know basically the two most common ways of protecting your IP, which is copyright, automatic, and trademarks, registration for your logo or word marks or other brands. The next part is about how to protect that IP. So up here is kind of the structure that a lot of IP-centric companies or businesses use, and one that we often recommend in terms of for people trying to protect their IP or other assets. This is, we essentially have a company up top called the IP owning company, which into which we'll pour basically all of the IP of the business. And then we'll have a trading company. Doesn't need to be three, maybe just one is fine, but basically a trading company at the bottom that will have a license to use the IP from the top IP owning company and basically do your usual business with it. So the reason why we set it up like this is because of the concept of limited liability of companies. So who here has their own company or for their business? Okay, so you might, well, since you've done so, you might know about, already know about the advantages of having a company, but the main advantage is limited liability, which means that if you as a shareholder of a company, you're not responsible for the debts of the company. If your company gets sued for $100 million, but you don't have that much, the buck stops at your company. And your company just gets put into liquidation and basically removed. But you personally, as a shareholder, won't have any liability for that $100 million debt or whatever. That's the concept of limited liability. So, given that concept, the aim of the structure here is so that your trading company does all your trading for you. We'll do all your usual contracting with your employees, with all your contractors, with your customers, with all your suppliers. Basically, any contract that might involve imposing liability on your company. So if the trading company is doing all that, and all the assets are up in your IP owning company, if your trading company, if someone tries to sue under one of the contracts for more money than your business is worth, let's say, then the trading company will go under, but the IP owning company will be fine, and so will the assets in it. So that's how we usually try to organize the business to kind of ring fence the liability from your trading. And this is the most common structure that we kind of recommend and see businesses use to kind of achieve that effect. Let's see. So yeah, pros that protects your assets. The other thing is when your assets are protected, investors are more likely to want to invest. In fact, it would be kind of discouraging for a lot of investors, especially sophisticated ones, to invest when this kind of structure isn't in place, or if they do invest, they want it in place quite soon after the investment, just because they want to protect their investment by protecting your IP. It also allows you to cleanly separate your different business arms. So if you say you had a business in, you had an operation in Australia and an operation in New Zealand, you could set up two different companies, two different trading companies. Let's see, I can go back. You can set up 2 or 3 different trading companies, one for each jurisdiction that you're in. And if one of them blows up in one of the jurisdictions, your other kind of businesses will still be fine. Let's see. And it also allows you to so what I meant by allocating ownership to the contributors of the business is that, let's say you have different operations in different jurisdictions. You can allocate holdings, or I guess shares, in those companies to different managers, but maybe in the various different jurisdictions. So basically, it's a very easy way to kind of split your business cleanly if you operate maybe different services arms in your business or operate in different jurisdictions. The cons are that the setup costs are much higher than if you just set up a company, just because you'll need a licensing agreement between the companies, and you need to transfer all the assets to your IP owning company. The administration will be higher compared to if you just own the assets yourself, because you need to maintain the company, and you'll need to likely engage an accountant to make sure that your tax liabilities are in the right place. So, given that, do you need it? The main question will be, well, what do you want to protect? What IP and what assets do you have? If you're just starting out, and we are a one-man band, you've got an idea, maybe you've got the logo created, and that's about it. It probably isn't worth it at that point to incur like thousands or potentially tens of thousands of cost to kind of get your IP checked and get this whole structure set up. But once you get to the stage where you say to yourself, "Oh, I can't afford to, lose my IP to a bad launch, or I'm ready to get investment," that might be the stage when you might want to consider setting the structure up. And in setting the structure up, there are a few considerations. The primary one being, well, what do you own, and what IP do you own, and what do you license? You can move the license agreements to the trading companies, and you can move the assets that you own to the IP holding company. And the other consideration is who created the IP or the asset. So this goes back to what I said earlier about copyright and automatic ownership, automatic protection of an IP asset that someone creates. If it's a contractor, then you need to make sure that the assets that they create will get assigned to you or the IP holding company that you set up, because if you don't, it might be the case that they automatically get copyright in what they create. But most contractor agreements should say that whatever IP that the contractor creates and doing services for you will be assigned to you. And that's one thing that's a lot of, I guess, smaller businesses don't get quite right, because they'll just engage someone. It'll be maybe on just on one email, say, "Hey, can you design this logo for me?" Or, "Hey, can you write this bit of code for me?" And then they'll be like, "Yeah, sure, here's the product," and then that's it. doesn't necessarily give you or any future investors any confidence that you have the ownership rights over that piece of IP or asset. So, continuing on that theme, there may be another consideration is in terms of whether should you set up the IP holding company structure, are there any restrictions on you transferring the IP? Because in order for you to protect that IP, you need to pour it all into that top IP holding company. And if there are restrictions on the assets that you own that prevent it being transferred, then you wouldn't be able to do that. So the main example would be securities, i.e., say you took out your business took out a loan from the bank, and the bank has a security over all of the assets of your company. Well, all of the assets of your company includes the IP that it owns. So if you wanted to transfer it out of your current company and into a clean IP holding company, you'll need to get permission from the bank to do that first. And other considerations in terms of any restrictions on transfer will be grants in relation to the development of the IP. If you were given a grant and you transfer that IP out of your company that was given the grant, what happens to the grant? Can it be clawed back? What happens to the IP? Can that be transferred out under the terms of the grant agreement? Other things to consider: have you licensed your IP to any third parties? Obviously, if you have your company that currently has the IP and you license your IP to some third party, you'll need to consider how that impacts the agreement you have with that third party, because if your company no longer owns the IP, it's kind of hard to license something that you don't own without another kind of license being created. So you'll need to consider that, and do any terms of the contracts that you are party to prevent you from transferring your IP. So, for example, some contracts say if you transfer a significant amount of your assets, then that's a change of control, and they can terminate the agreement or whatever. And that might be triggered upon you trying to transfer your IP into this new IP holding company. So this is one of the major things that I like to talk about, which is what happens what you need to consider if you want to set up this IP holding structure, if there are multiple founders or multiple shareholders. So it's not just you, not just a one-man band. Maybe it's 5 people together who come together and create a game. So how, if you're setting up a company structure, well, have you decided how to split the ownership of the business? Often that's a conversation that needs to be had between founders who basically haven't given a thought about that yet. And if you are formalizing your split in the ownership of the business, do you have a founders agreement in place or a shareholders agreement? Which is a very important document, actually. So what a shareholders agreement is basically a contract between you and the rest of the shareholders of the company. And it basically governs how you guys will administer the company, and how the governance of the company will work. So basically, issues like appointing directors. Who gets to appoint a director? Does everyone get to appoint a director? What happens if they sell their shares? Do their shares get offered to everyone else first, or can they just sell it to anyone without any restrictions? What happens to the director if they sell? And so on and so forth. And it's important issues like that often don't get thought about, but are very important when or if things get pear-shaped, because obviously you don't need any contract in place when everything is going well, everything operates on trust, and everything is fine and dandy. But when say someone's circumstances change or opinions change and founders become less aligned with each other, that's when problems start to occur, and that's when you will be very glad that you have written down what needs to happen in a shareholders agreement or a founders agreement. In previous years, I went a lot deeper into shareholders agreements and what considerations go into them, but I got told it was too boring, so I had to cut it. But it's very important, and I like talking about it, so feel free to ask questions on it at the end. But in terms of when you need to get a lawyer, it will be because setting up a company, setting up multiple companies even, is actually very easy to do. You can probably do it yourself just on the company's office. There's a guide on how to do it. Costs maybe like 150, 200 bucks per company. So very inexpensive, very easy to do. The hard part will be preparing the documents to transfer your IP into that top IP holding company, and then arranging licensing agreements between the companies so that your trading company can properly use the IP that's owned by the top company. That part people might struggle with a lot more unless they are also IP lawyers. So while you can kind of partially do the structure, you kind of do need legal input at some point in order to kind of perfect it. Another thing that I like talking about, and that I was told to cut because too many eyes glazed over in previous years, is capital raising. I went into a lot more detail about capital raising in previous years, but essentially it's when your business needs money and you want to raise money from outside investors. So, and this is relevant in this context because those investors will want to see that you have your house in order and that they're not giving money to someone who's not professionally advised, basically. These structures will allow for much easier investment by those investors because all they need to do, or you will need to do, is issue them shares in the top IP holding company, and that's where they'll want their shares anyways, because that's where all the assets, your crown jewels are, in the IP holding company. So in a cap raise, you would issue shares to them in the top IP holding company, and they'll inject money into that company. And then obviously the money can kind of flow down to your operating companies or trading companies at the bottom as necessary. And just because I couldn't resist a few capital raising considerations if you were to kind of look to raise money from investors, is keep in mind that your goal is to give away as little of your business as possible, as few shares as possible, for as much money as possible. And in my experience, this really just, because you're, especially in early businesses, because early businesses don't have a revenue kind of record yet. You don't have any track record of say, hey, we're earning X $1 million of profit per year. Sometimes you have to get an investment before you even start getting any revenue. And at that stage, it really just depends on your pitch. You need to basically do your best to sell them on the success, future success of your business. And try not to go out to investors unless you have something more than just an idea, unless that idea is really, really amazing, most investors will want to see kind of maybe a working prototype or something like that, minimal viable product, as they like to call it, before they will consider investing. And another important point is that make sure your investors' goals align with yours. A lot of people see raising capital as just getting money, getting as much money as possible, and then that's it. But that's not really the end of the story. What happens is that those investors will end up on as fellow shareholders alongside you, and they'll get a say in what happens or the direction of your business. So make sure that your goals align, otherwise there'll be a real pain or a real thorn in your side going forward. And sometimes you might think that the money they gave you was just not worth it. Get advice on the rights that you're giving to investors. Yeah, so investors will often ask for a bunch of rights to protect themselves and protect their investment. And sometimes it's kind of not so intuitive what those rights mean, what they mean for your control of the business. And that, yeah, it's just very important to understand that when you may be giving away control of your business when you don't actually mean to. And the last bit is issuing shares. You'll need to issue shares to them in order to get money from them. It can be tricky. There are a few, there are securities legislation which govern the issue of shares, and you will need to comply with those when you issue shares to investors. So I guess the main thing I'm trying to say is get advice on when you're trying to do a cap raise, unless, of course, you're raising very little and the advice would cost more than your cap raise, in which case, good luck. The next part, the game. Okay, so legal issues relating to the game. Developing, so let's see, developing game, yes, licensing, developing, licensing, okay, and complying with laws. So this part is really about the components of what's basically legal components of what's involved in distributing your game and creating it. So you may have a platform or engine agreement with maybe you want Steam to distribute it. It's built on Unreal. You make sure to read those agreements. If you're unsure, get legal advice and get someone to review it, because you don't want to end up in a situation where you think you can do something with their product that you can't, or that you thought that they were going to perform a service for you that they actually wouldn't do. Stuff like exclusivity. Does it prohibit you from releasing the game on a competing platform? Stuff like that, if it can be quite jarring if you just not aware when you sign up to it. Game development agreements, essentially these are contractor agreements. If you get any third party, whether it be just a random guy you know or a coding house to help you in developing any part of your game, or such as coding, those are agreements that you need to ensure have clauses in them that assign the IP in the game or game assets to you. And if you think back to the IP holding company structure that we discussed earlier, these contracts with these third parties will be entered into by the kind of companies at the bottom, the trading companies. So we want to keep these contracts away from the IP holding company at the top. So that's just another kind of another aspect that you want to keep in mind when you enter into agreements. Just make sure that they're always, if you use this structure, that the agreements with third parties will always be with your trading company at the bottom, so as not to expose your top IP holding company to any contractual liability. And in terms of warranties that you expect from game development agreements, think about things like, does the app or the asset they are developing meet specifications? Does it do they have warranties that the product meets specifications, that the product doesn't infringe on any third-party IP rights, i.e. didn't steal someone else's IP to make this piece of IP for you, and that no open source software is used, or maybe you're fine with it depending on the type of open source software that was used. So those kind of warranties are kind of important to get from third parties who are kind of coding for you. So developing the game. So when you contract a third party to create assets for your game or business, you need to make sure that the contract states that they will give ownership of the IP they create to you or the holding company. That's basically the takeaway from contracting with third parties to create IP. When you use third-party IP, however, you just make sure that you have the appropriate licenses and that the terms of the licenses allow you to use that IP for what you want it to. So some free assets, for example, might forbid commercial use. So just be sure to read the terms on which you're licensed to use something if you're using something that's not yours. And regarding open source software, so again, it's a license, so be sure to understand what you can and can't do with it. And what you must do, in terms of open source software, what you must do if you use it. Some of you might be aware that that some open source software kind of demands that that whatever you make using that software must also be open source, in which case that would be a disaster if you were using it to develop proprietary software or code. And I guess the topic of the year, AI. What happens when you use AI, when you use generative AI to create assets? So the simple answer is that the jury's still out at the moment. And so you need to be very careful when using generative AI to create any of your assets. We've seen basically a lot of businesses just say, don't. Err on the side of caution to say, just don't, for now. Because you never know how those copyright cases that are still in the courts at the moment might swing. And if you are using, if you are using an LLM to create assets for you, check the terms of use for that model and see if it assigns the ownership of the outputs to you. I mean, if not, then your consideration of whether to use that model probably just ends right there. But often, an example with businesses using AI is privacy, because a lot of businesses will need to enter sensitive information or personal data into the LLM. It's probably maybe it's less of an issue in game development. But if, for example, you're using an LLM to power an NPC who can respond to players, then you'll need to be conscious of kind of how that LLM handles any personal information that gets disclosed to it during conversations with players. So that's just an example of where kind of your business might come into position of personal information or sensitive information, and you'll need to know kind of how to handle that. Let's see. Another interesting topic that has come up for us recently is Web3 games and issuing tokens for use in Web3 games. Essentially, the New Zealand position is relatively, it's relatively relaxed on it, but the main takeaway about the New Zealand position is that as long as they're not, as long as they're utility tokens and they're not like a share in a company, then in many cases you will be fine. But it's a very case-by-case kind of judgment. So this is something that you definitely want to get advice on if you are planning on issuing any sort of crypto token for your game. Just because the authority overseeing these tokens do have the authority to just say, look, we think your token is too close to being a share or has these attributes, and therefore we think that the regulations will apply to you. And if it's a utility token and it's not considered a financial product and therefore regulations don't apply, then the other consumer laws will apply, such as the Consumer Guarantees Act, because you're essentially selling a product. And one thing that we've seen is that it's quite difficult to release even utility gaming tokens in certain countries, such as the US, China, South Korea. So basically, a lot of big markets just basically make it very, very difficult for to release utility tokens for games. But in New Zealand, it's quite lax on that. So a lot of these Web3 games do get released in kind of New Zealand, maybe as a kind of a test case first. But it's a space that's where it's under development. So I guess it's a kind of watch the space kind of moment there. Licensing. So anyone who's used Steam will probably know games are licensed, not sold, unlike the old days. The piece of software that you sell that users buy, essentially, it's you give them a license to use that software, and the license says that they can use that software within certain restrictions, but you still own the as a developer still own the software. Of course, there are movements such as Stop Killing Games, which is trying to kind of change this model a little bit. But by and large, games sold digitally nowadays with a EULA or end user license agreement, which governs how the players can use your software. It's essentially the pop-up that comes up when you go to install the game and you click OK without reading it. So that's what it is. It's and in terms of the bottom bit, which says that your EULA should address warranties, the warranties often include, if our game breaks your PC, it's not our fault, and if it is our fault, then we don't have to pay very much. Those are the kind of warranties that you would expect to see. So just rushing through these bits now, so I'm conscious of time. Probably can take that, just some more considerations about what to put in your EULA, depending on what kind of content that you have. We can probably skip this one. So this is the last big topic I want to talk about, which is compliance with the various legislation in New Zealand when you go to sell your game. This has become a much larger topic recently, with the New Zealand Commerce Commission coming out and saying that they've done a scan of the industry and found that some people basically need a reminder of how not to breach the Fair Trading Act and the Consumer Guarantees Act. And many of you may have seen that open letter that the NZGDC received from the Commerce Commission. And in fact, they did a presentation on this, I think it was Friday. But if you haven't seen that letter, it basically says that discounts have to be genuine, they can't be on sale all the time, and time-limited sales must actually be time-limited. Free-to-play games must be actually free-to-play, and you can't mislead gamers about their rights. You can't say, oh, you can't refund this game after 2 hours of play, because if the game has serious issues, the consumer will be covered by the Consumer Guarantees Act no matter what, and no matter what your refund policy says, and you'll be entitled to a refund. But funnily enough, the EU also did a scan of their gaming industry early in the year, before the New Zealand Commerce Commission. And the EU's investigation kind of centered on in-game currencies, and they sought to discourage practices like not having a real world dollar price next to an in-game purchase. So now, I guess nowadays you'll see a lot of in-game purchases have an actual dollar price next to it. They also want to discourage obscuring the real cost of making a purchase, such as making you buy one currency to convert into another currency to convert into another one to exchange for the item that you wanted. So they want to discourage practices like those, and not having the exact number of premium currency, let's say gems, available for purchase. So if an item costs 80 gems, but gems are only sold in packs of 100, then that forces the player to kind of buy more than what they need. That and exploiting vulnerabilities such as age or mental infirmities. It was looked down upon by the EU Consumer Protection Cooperation, and they said that they would be looking closely at games whose entire models revolve around exploiting whales. So an interesting space to kind of keep your eye on, especially if you're developing a game with microtransactions. And I think I will end that there so that we have time for maybe a question or two. I'm aware I went through that a bit quickly, but any questions? Oh, no. All right, and in which case, I will release you.